Good evening, this is John Milburn for Laws 12067. This is Environmental Law. We're into week 3 of term 3, 2019. Thank you all for joining me for the live session. We will attempt to make this interactive to some degree, to the degree that you'd like it to be interactive. And for those of you watching the recorded session, please consider joining us for the live session. We appreciate it, and it is a much better session, I think, if we can have some interaction with students. Tonight we're dealing with the common law, and essentially we're jumping around a bit in terms of where the environmental law is derived when applied in Queensland in particular. As we discussed in weeks 1 and 2, this is very much an area of law that is multi-layered. I say that because we've got the 4 basic layers of statutes and regulation on the one hand, and then we have the common law with equity on the other. So if we look at international law, federal law, state law, local council law, on the one hand is one stream, and then on the other, judge-made law, the common law of Australia, but broken down into aspects of common law and equity. We really have 6 areas of law that might intersect to provide us with an answer in relation to an environmental law problem. So the point is that when we're attempting to apply environmental law in a practical sense, we need to be mindful of the interplay of these different sources of law. Now, they're all essentially primary sources of law. On the one hand, the stream of 4 is, if you like, statute law, and on the other is the case law. I'm stretching the definition of primary source of law a little, in that technically it wouldn't include international law and potentially regulations as well. We normally think of statutes and case law as primary sources, but I think for the purposes of environmental law, we need to be a little more broad in our approach. Now, before I start to talk about the substantive aspects of this week's topics, just a reminder that I would like to see people answer tutorial problems. And we will, time permitting, have a look at some of those tonight. And I think it's important that you answer the tutorial problems for a few reasons. The first is that it means that you're keeping yourself focused and preparing essentially for the final exam. You know what the first 2 assessments are, but we don't know what's in the final exam. So the more that you prepare by answering the weekly problems as we go, generally speaking, the better placed you are to answer the final examination. The other thing is that it provides you with an opportunity to obtain some feedback in relation to your work. Now, with the quality of students in this class, this unit, that feedback won't necessarily come just from me. So I would encourage people to, very nicely, and I'm sure you will, critique each other's work. So with the weekly problems, if you are preparing them but you just haven't uploaded them, I'd encourage you to do so. And if you haven't prepared answers to the weekly problems, I'd encourage you to do that and then upload it through Moodle. We'll talk more about that later this evening. So a starting point for me tonight is the concept of delegated legislation. Can anyone tell me why delegated legislation would be a particularly important concept in the application of environmental law in Australia? Any thoughts? I guess we need to know what delegated legislation is and then think about how it might be applied in environmental law context. Now, any thoughts on, firstly, what is delegated legislation? Feel free to unmute your microphone if you wish. I know we covered this in... Yes, David?
Is delegated legislation the type of legislation that the executive, such as departments, can use to enforce the objects of what they're trying to do as a department?
Exactly. We could probably even go a little further with that response and say that it's not just the departments in using them delegated legislation, but departments actually making the laws pursuant to the powers conferred upon them through the delegated legislation. So it's lawmaking at a council or a governmental executive level is probably the best way to put it. And that's quite often ministers of the Crown, but it can be other government officials, it can be local councils, it can be even individuals. So the delegated power, legislation power, as David explains, is where Parliament has provided an opportunity for individuals or groups or bodies to make laws. So that's what delegated legislation is all about. So that's the first part of the question. The second part of the question is, well, why is that important in the context of environmental law, perhaps arguably more so than in most other areas of practice, certainly more than I can think of. Why is it important?
Because it relies heavily on statute law?
Yes, yes, that's a good point. Environmental law per se does rely disproportionately on statutory laws, on statute rather than common law. I'd agree with that. That's good. And
it can be crafted to deal with specific situations. It isn't a one-size-fits-all.
Yes, I think that's a very good response as well. And as we'll see in environmental law, in some ways, the legislation is quite broad brush in its application. You know, it's a bit like I'm doing contract law at the moment. So I'm dealing with Contract B and I'm dealing with the Australian Consumer Law, Section 18, you know, prohibiting unfair practice and, you know, just general statements. Environmental law is a little bit that way. You can almost have legislation saying, you know, take care of the environment. And then from that general principle, that statement in the statute, then the detail filters down through delegated legislation to council level, for example. So when it comes to lawmaking in environmental law, we have the very broad general statements of principle, which usually comes from international bodies, that is then embodied in greater detail, but still in a fairly broad way through statute. But when it comes to the nuts and bolts, the mechanisms, the way things work in practice, very often in environmental law, we're looking at councils, laws that have been made through the executive as a result of delegated legislation conferred and authority conferred upon those executive bodies to make the laws and then, as David points out, to enforce and regulate those laws at that level. So it's quite complex. And really it shows that lawmaking now is quite complex. There's much more regulation in the process of government control than was the case, say, back in the 19th century, when most of the law was created through judge-made law and common law. So scientific developments have a part to play in this. As science, the body of science grows, it's incorporated into our law to some degree through statute, but very often through delegated legislation. Can anyone give me an example of what we mean? Just you can give me a specific piece of delegated legislation, but what are the general names that we would give to delegated legislation? What are some of the examples?
Planning schemes?
Planning schemes, yes. Yes, David?
Did you mean like a specific act, such as like the Vegetation Management Act of Queensland, or?
No, that's still legislation. That's not an example of something that has been created as a result of delegated legislation. So it's still an act of Parliament. What I'm really getting at, I think Sarah was on the right track here, a planning scheme is an example of delegated legislation. usually the main source of delegated regulations. So if you see things like regulations, bylaws, ordinances, planning schemes, they're all examples of delegated legislation. So that's more what I'm getting at.
So the Biosecurity Regulation of 2016 would be an example of that stemmed from the Biosecurity Act of 2014 or something like that?
Perfect. Yes, that's right. So what happens is that we often have a statute, and hanging off that, as it were, we may have a regulation. Or it may be that there is some form of delegated legislation to which there is not a corresponding statute. And we see that a lot in environmental law, as Sarah pointed out, planning schemes, for example. Now, the key, of course, is this, that because there is quite a lot, relatively speaking, there is a lot of delegated legislation that we need to consider in environmental law. And what that means then is that the governments through Parliament have essentially, those of you that have played rugby, you might know the halfback role, the traditional halfback role, grab the ball and flick it on out to the back line. So Parliament have assumed that role in some ways. They've created the law, but then flicked it to the executive to create the detail. And it's much easier to change regulations than it is statutes as well. So regulations can be more nimble in the way they're created, the way that they're applied, the way that they're changed. But one of the problems, of course, is, and Parliament doesn't have time to make all of the laws, partly because they may not have time, but it may be in some ways too trivial. But environmental law, I think, is a special aspect to this, in that there's particular expertise required to frame the laws through delegated legislation. And the expertise is often found at the executive level, no disrespect to our politicians, rather than our parliamentary level. So, at Parliament, we can make general laws, but the specific laws that rely on scientific information, the expertise that's required is normally at that executive level. So if you see bylaws or regulations or rules, they're examples of delegated legislation that has been created. In the case law that you read, particularly when we get to about week 6 and we're talking about planning, you'll see that many of the cases relate to local councils. And many of the disputes relate to delegated legislation created by local councils. So I've mentioned that I would like you to pursue and read a few sample cases. And I think I mentioned a couple of them last week rather. And the one for this week is Predjon against the Cairns Regional Council. And part of the reason that I've selected that is that I had done some work with people, including Rob Litster QC, as I mentioned last week, and you'll see some information on Moodle about that. So that's an example of where there was a dispute involving a local council in relation to delegated legislation that was created at that level. And delegated legislation deals with a whole range of things, doesn't it? It might relate to roads, planning, recreation areas, building codes is a huge area as well. So when we vote for our local councillors, we're asking them in some ways to create laws, that which has been conferred upon them by Parliament. And I mentioned last week, the first thing that you do, if someone's being prosecuted under a local law, what's the first thing you do? We know this because I told you it last week. If you're on the defence, someone's been prosecuted under a regulation, any takers? We check to ensure that the body that created the delegated legislation, which is being relied upon in the prosecution, had the power to make that. And it might seem obvious, and you might think, oh, well, surely they wouldn't create something if they didn't have power, but they may have overreached. So you've got to ensure that the local authority or the body that's been delegated with this power to create legislation actually had the right power. And you can go one level up on that and make sure that the statute was created in accordance with constitutional power. And courts are very much careful about this because there's an obligation, of course, for citizens to obey the law. And courts are very conscious about the potential overuse of delegated legislation and the abuse that might come with that. So the courts will not only look at whether the delegated authority was provided lawfully, and therefore the delegated legislation was created lawfully, but also to ensure that the process by which that came into account was done lawfully. And as David would say, if you're looking at regulations, you've got to ensure that that is consistent with the Act as well. Now, I'll just ask you this. If you've done advanced statutory interpretation and drafting, which I've had the privilege of taking over the last 2 or 3 years now, you'll know about disallowance. Has anyone come across that concept of disallowance? It's relevant to this area of practice because when we talk about delegated legislation, it means that Parliament is delegating to the executive the power to actually make laws. But Parliament still retains some control over the delegated legislation. And some delegated legislation must actually go before Parliament before it becomes law. And each House of Parliament, at least at a federal level and in most states, has an opportunity to consider it. And the Parliament has the power to disallow it. So that's what we call the power to disallow. So effectively, it's a right to veto that's still retained in some instances for delegated legislation. All right. Have I hit you with too much information, or are we following all this?
Is
And
that idea of disallowance similar to what is being attempted at the moment by the Queensland Farmers Federation in regards to the up-and-coming reef regulations? It's been in the news recently where they want the reef regulations are being created and they know what's coming, but they're sort of trying to appeal to actually have those regulations decreased or not or loosened.
Yeah, I'm aware, but only in a general sense of what's going on from the news clips that I see. But certainly in many instances where the executive has substantial power, important powers, Parliament has the ability to not recreate or redo the legislation, but essentially disallow it. So, and quite often Parliament will act as a result of the influence of lobby groups. So perhaps indirectly, David, the answer could well be yes, but I don't know for sure, I'm sorry. But it's along those lines. All right, so have we got a good idea of what we mean by delegated legislation and what we need to consider, particularly in a prosecution? All right. Now, of course, the topic for tonight is common law, and I've done nothing but talk about delegated legislation. So common law, of course, is judge-made law. And I think it's, I forget the name of the case, Lay, I think, but I'm not sure. But there was a comment in a High Court decision trying to explain what we mean by common law in Australia, because it's that strange amalgam between the common law in its traditional sense and equity, the decisions in the equitable jurisdiction. And because they've merged now, essentially, the decisions that were based on common law principles and the decisions that were based on equitable principles are now done through the same courts, often at the same time. So when we talk about the common law, when I talk about the common law, I'm really talking about the common law of Australia, which is essentially judge-made law in a global sense, irrespective of whether the judges were applying common law principles or equitable principles. So when we're talking about the common law, I'm really talking about judge-made law in a general sense. All good? All right. And of course, in environmental law, unlike torts law or contract law, its common law is very much secondary to the statutory law. But of course, it's still important. Why is the common law still important, even though I've been saying that environmental law is overwhelmingly statute-based in its operation?
Common law dictates interpretation and application of the statute law.
Exactly. Thank you, Sarah. Yes. And another thing is that when we're looking at the statutes, we need to interpret them in a way that's consistent with the common law in most instances. And because we're dealing with a lot of statutes, we need to remind ourselves of all those things that we learned in statutory interpretation. And some of you may have undertaken 11059 statutory interpretation with me. So you'll know that I'm keen on you talking about Project Blue Sky. I think I mentioned that last week. Things like that. So don't toss away your statutory interpretation ideas. Introduce them into your answers in relation to environmental law where appropriate to do so. So the thing about common law, though, and the common law principles was this. Mostly when it comes to the environment, at common law, there was no principle in relation to environmental law or environmental protection. So when we're talking about the environment, we're really talking about the physical being, the physical world around us, aren't we? In one way or the other. And in relation to the land, the physical land, that was all dealt with through property law rights, and the common law recognised and protected interests in private property. That was the main focus of the common law. So when it came to introducing environmental policy, environmental protections, statutes had to overcome this long-held notion that land carries with it the right of the landowner to do whatever they want with their land, subject to not interfering with the rights of their neighbours or creating some sort of tort like nuisance or negligence. So that was the starting point that we had to overcome. So the common law effectively was not able to protect the environment, which is why we have legislation introduced to do that. But when we look at this legislation that's been introduced, we still need to consider interpreting it in accordance with recognised common law principles and common law concepts. And Jerry Bates, in his book, refers to a lot of this in more detail. So there's a fundamental tension, isn't there? A fundamental tension between that which the common law has traditionally protected and that which the statutes intend to introduce. To protect the environment, in short, on occasions, you may need to adversely affect the interests of the landowner. If the common law was there to recognise and protect the rights of private property holders to do whatever they liked with their property, then statutes that interfere with those rights to knock down trees, to remove vegetation, to interfere with water supplies, to pollute, to deal with native fauna and flora, are all interferences with the rights that property owners traditionally had. And there are some limits, of course, that need to apply here. So let's, for a moment, put on our cap of looking at environmental law from the perspective of a traditional landowner. Now, let's assume that we're talking about a large parcel of land that's being used by the landowner for a particular purpose, whether it's farming or fishing or something, logging, for example, and a statute or someone seeks to take away their rights. What are some of the things that we need to consider? Now, remember, of course, that when I said when it comes to the final assessment, you may be asked to look at environmental law from someone's perspective. Now, we're looking at it from the perspective of the landowner. And they come to you and they say, I'm not happy because government is wanting to interfere with my ability to do things. What are some of the ways that you might approach this problem in a general sense? I know that's a very vague question, but are there any thoughts? Yes, Karen.
The landowner could try to sue for compensation for
Yes.
loss of whatever it was. If for instance, it was a tree plantation.
Yeah.
And the councillor said, no, you can't do that anymore, then obviously that's an income that they've lost.
Okay, I agree with that. Compensation might be an avenue of attack. But there's a level before that, isn't there? Before we get to the issue of compensation, we have to consider a preliminary issue. And I've alluded to it already tonight. See if you can pick up. Yes, Caroline.
Is that whether the council or the wait, I've written it.
Yeah, I think you're on the right track.
Whether the body that's actually trying to enforce whatever it may be, whether they have the right to.
Yes,
it's
that's it.
Power
I
to
think
that they have the authority.
That's right. I think that's a good starting point. So before we concede, let's ensure that whoever it is we're dealing with has the right to act. Now, generally speaking, to follow on from Karen's point, let's assume that we are looking at a compensation claim. If the right which is under attack, which might be the subject of compensation, but if the right that's under attack is being attacked by statute, then that may well be fundamentally different to a situation where the right is being attacked as a result of the introduction of delegated legislation. If the statute is Commonwealth, that may have a different bearing on the issue of compensation to if the statute was state-based. Let's talk about that for the issue of compensation as a result of dealing with Commonwealth legislation versus state-based legislation first. Why should it make a difference to the issue of compensation? Any thoughts? Tricky question.
Is this something? I was watching your pre-recording podcast and you talked about a scheme for liability in lieu of suing at common law. Is this something along those lines?
That's a little further down the track.
Okay.
It's a good thought, but it's not exactly what I'm looking for at the moment. And the hard part is, of course, I'm asking you to read my mind, which I appreciate is a fairly difficult task.
Isn't it related to the fact that where compensation comes from?
Yes.
Like it's from the Constitution, so it's national, and so states don't actually have a legal obligation for compensation, and most of the time they try and rule it out as an option where someone's been shortened by a law that's been put in place by a state.
Yes, that's what I'm after. So thank you. So it's at that constitutional level. So thank you, Sarah. So is there a constitutional right conferred on individuals who have their property taken from them when we're dealing with Commonwealth legislation? We've all seen the castle. Yes, that was Commonwealth legislation that was being used to attack the landowners' rights there.
Yes, they do under the Constitution because it requires a fair and equitable
That's it.
compensation for the
Yep.
loss.
So when you're looking at a question that relates to individuals who are under attack in relation to the use of their property, develop a little flow chart for yourself. But I think at the start, we need to identify, is the power being exercised or purported to be exercised lawfully being exercised, which means from where has this power derived? If it derives directly from statute, is it Commonwealth? If it's Commonwealth, we then need to consider the Constitution, which provides for just and equitable compensation in relation to property rights being taken from an owner. If it's state-based, Sarah's correct. There's no specific statutory provision that requires or mandates the states to pay compensation in those circumstances. So that's a starting point. Second thing is, if it's the executive power which is being exercised in relation to the purported taking of the rights, then I guess a question is, does the executive have the proper power? Was the delegated legislation properly made? Were all process properly undertaken? Assuming that was the case, then the question is, can the executive effectively take away common law rights? Statute can. I'll give you that hint. So statutes override the common law, don't they? We know that from introduction to law. Statutes override common law. So if there's a common law right, a statute can overtake that. It can take it away.
But isn't that restricted to having, they must have like a specific and clear intention that they're intending to override that right?
Oh yes, yes. It's got to be clear. It's got to be clear in the legislation, but through legislation there is that power. Parliament does have that power to overrule common law rights. But when we're talking about the executive, which is very often what we're doing, and this is where this is my little tie-in between the preliminary part where I was talking about delegated legislation and now the common law. If we have a fight, for want of a better term, between delegated legislation and common law in relation to taking away property rights, which one wins?
Isn't there a case called Vaughn versus Forestry Commission of New South Wales, which sort of looks at that in terms of executive decisions?
You've read my mind exactly. That's exactly the case that I had in mind, and that's the best authority to cite. What happened in Vaughn? Do you know?
Wasn't it about access to? Was it water access? I can't quite.
It was water. Yeah. So very good, David. That's exactly what I was looking for. So in Vaughn, as I recall, and the citation is Vaughn against Forestry Commission of New South Wales. It's a 1995 decision. It's in your text. So do look at this part because it's a key aspect. The issue was in relation to licensing, and under this scheme, the license had the effect of restricting, I think it was access to water. That was challenged on the basis that the executive did not have the power, even through licensing, to effectively take away common law rights. And as I recall, the plaintiff succeeded in that case. So only statutes can effectively take away the legal rights to access water, was the decision in that particular case. Now, every case is a little different, and we have to be really careful about this, but there are different ways of dealing with it. Now, Karen raised a good point and said, well, it may be that we seek compensation. So if our first argument is, well, do you really have the power to do this? But if you do, we'll seek compensation. And the state governments often have funding, which is Commonwealth based, to enable it to pay suitable compensation in certain circumstances, or it may have its own funding. Or it may be some statutory adjustment schemes, or it may be some other way of offsets, for example, of compensating in certain circumstances. So the takeaway is this: if you're looking at something which has an impact on a landowner and it's environmental law based, think about whether it's something which is being taken as a result of a statute or through an act of the executive, delegated legislation. Think of either way whether that's lawful. If it is lawful, then think about whether you can ask for compensation. Think about whether there's some other way of obtaining compensation, which I think comes back to, who was it that raised my pre-record? Was that you, David, or that was Karen? It comes back to your point, Karen, in terms of statutory adjustment schemes, for example. So there are different ways that we might be able to get round this issue and have compensation anyway. All right, so just on the common law and the way in which it interacts with the executive, have a look at Precautionary. You don't need to study it in great detail, but it would be worthwhile having a look at so that you get a good idea of how it works in a practical sense. Any questions before I move on a bit?
I looked at that video of Precautionary with Rod Lister QC and listened to that, and it's quite interesting about how they had to look at sort of legislation in a retrospective manner, and it was that clash of where there was contemporary legislation and then when decisions were made further back in terms of the application, and became quite a confusing issue that had to be sorted through as well.
Yes, it was quite a complex matter, absolutely. And one of the problems, of course, is that because this is legislation based, the legislation does change. And I think I mentioned earlier that we've been through the Integrated Planning Act, the Sustainable Planning Act, the Planning Act, all in quick succession in Queensland.
And just as an FYI, I'm not sure if it's still the Precautionary, but they're having another try at developing that site.
Oh, is that right? Do you know that site, Karen?
I live in Cairns.
Oh, okay. How far out of Cairns is it? Like half an hour?
Oh, not even that far, really. It's just as you head north out of Cairns, only about 10 or 15k.
Is that right? What's the name? It's something Point, isn't it?
Taylor Point.
Taylor Point, yes. Yeah.
Now, as of early this year, someone else is trying to get development.
Oh, okay.
Trying to get development.
Well, we'll look.
Everything.
We'll look at stage 2 of the litigation. It looks beautiful spot. It looks a beautiful spot.
Oh, it is. Everything up here is gorgeous.
I'm sure. All right. So thank you, Karen, for that. And then, of course, when it comes to compensation and schemes, there are different schemes. So biobanking is one that you might look at. It was introduced in New South Wales under the Threatened Species Conservation Act, and it provides for biodiversity credits under biobanking agreement for offsets and on the impacts of the development. So
is that another sort of version of what's called natural capital, or investing in natural capital?
I'm not familiar with that term. I should be, but I'm not. Sorry. You can feel free to expand on that, David, if you wish. But
there's the concept of natural capital. I'm not an economist, or a business person, but I do believe that there's this sort of idea that businesses look at the idea of natural capital, where they can invest in sites where they could basically profit from it, but in different types of ways, such as that, or use that in a profitable manner. Yes. I think it's called natural capital. It's sort of more of a, I guess, an economics type of thing, but I'm not familiar with it. I was just wondering if you may know about it.
No, I'll keep an eye out for it though. Thank you. All right, so when it comes to common law, we know that legislation can overrule it, and it does override common law rights. And landowners particularly will often oppose the legislation, particularly if it means restricting access to the natural resources through tree removal restrictions or some other restriction. And so therefore it's fair to say that all environmental-based statutes will to some extent modify the common law rights of private landowners. And oftentimes the entitlement that is lost is the subject of some form of compensation. That might be a voluntary compensation that's provided, or it might be a statutory-based compensation. And it'll be statutory-based at a Commonwealth level if it relates to property. And it's not always easy to identify what we mean by that. So in the castle, for example, if there's a resumption of the entire property, then that's pretty straightforward. You know, that's a resumption, and that is compensatable under the constitutional provisions. But if we're talking about not having the ability to cut down as many trees as you thought you may have had in the past, is that really affecting your property? It might be affecting your property rights, but is it affecting your property? So when you're thinking about compensation, just try to tie in what is being lost with what is compensable, if I can make that general statement, either by statute or under a scheme that relates to it. So the other thing is, have a look at Kedge and Rutile against chalk. It's in the study guide, as I recall. And the takeaway from that case is that if a promise is made by a government agency during negotiation, then if that fetters the future exercise of a statutory discretion, then it's void. The takeaway from that is that if you're representing a landowner and you're engaged in discussions with government agency, then just be careful about the extent to which the government agency provides promises, because it may be that that promise is void if it interferes with future statutory discretions. I know that's a lot of words, but I hope that makes sense. Which leads me then to the next topic. If we're talking about people in the executive purporting to exercise powers, I've already raised the issue of, well, do they have the statutory or executive power to actually exercise, to do what they purport to do? Now, sometimes if they don't have the power, those officers might in fact be prosecuted. And if they're prosecuted, now let's look at it from the perspective of the executive now, and you're being asked to represent someone who made an executive decision which proved to be void, invalid as a result of lack of power, you may need to come up with a defence. Can anyone think of any defences that might be available in those circumstances? The general defence that I'm looking for is the defence of statutory authority. So sometimes regulatory authorities commit a nuisance or a negligence or do something, and Parliament has provided that statutory authorities give an exemption from those consequences in some circumstances. In other words, if the executive officer was acting in good faith and in pursuit of a statutory function, then they have the defence of statutory authority to rely upon. So I think that's always a good starting point to consider if the question in the exam asks you to represent someone who is in a position of authority that is now being challenged as to what they're doing. Have a look at also Section 319 of the Environmental Protection Act 1994, Queensland. Section 319 deals with the concept of general environmental duty. And it basically says that a person must not carry out any activity that causes or is likely to cause environmental harm unless the person takes all reasonable and practical measures to prevent or minimise the harm, and we call that the general environmental duty. So again, if we're looking at defence provisions, that might be useful in that the defence might be that the person may have done something wrong, but did so within the concept of general environmental duty by taking all reasonable and practicable measures to prevent or minimise harm. Okay, so just keep that in mind as a general thing for obligations, but also as a defence. Now, I mentioned last week the precautionary principle. I'll mention it again now, just because it's an important fundamental principle, and hopefully by now you've created some form of overriding document where you keep track of some of these important principles. So can anyone tell me what the precautionary principle means or what its components are? It's all right if you don't have it now, but homework this week is I would ask you to write 300 words on the precautionary principle. You can upload it to Moodle if you can find somewhere to put it, but just have that ready to go for an exam question. So the precautionary principle is something that deals with how decisions are made, how the decision might affect the environment, how it might affect future generations. It's clearly a very important concept within the context of climate change, which creates a range of difficulties for policymakers and requires new ways to deal with those issues. But the precautionary principle has a number of components. I'm not telling you what it is, but I'm telling you what some of the components are because I want you to fill in the gaps. So you need to take preventative action in the face of uncertainty. So the precautionary principle is a principle that mandates and compels proaction. So you must take preventative action in the face of uncertainty. It shifts the burden of proof to the proponents of an activity to prove that proceeding with this activity is consistent with environmental safety and policy. It explores a range of alternatives to possible harmful action, and it increases public participation in decision making. All right, so homework, have a look at the precautionary principle. Now, the final thing that I'd like to touch on tonight relates to some of the problems that we've had and the problems that are in the weekly guides. I hope I won't embarrass Sarah and Carolyn by identifying them as the only two that I can see that have contributed to the weekly problems. Thank you for doing so. I'm sure that everyone else has got answers to them, but just haven't uploaded them. So please feel free to upload, as I mentioned earlier. Question 2 related to the nature and structure of environmental law. And we talked about that a lot tonight. So when it comes to the structure of environmental law, we know that we're dealing with the separation of powers. We're dealing with Parliament and the executive and the judiciary. But in terms of Parliament and the executive, we've talked about the ability to make laws. And then from the perspective of the executive, to then go about enforcing those laws, primarily through regulation. So whenever you see a case, whenever you see a section, whenever you see a regulation that provides power to enforce, think about not only where did that power emanate, from where did it derive, but also what is the type of power that's being exercised by the regulator, and a whole range of them. So it's not just prosecutions. So keep an eye out for the sort of things that that people can do. and think about whether the power actually affects property ownership, and think about the Vaughn case. If you don't have Vaughn, if you haven't made some notes on that, I would recommend that you do so. And the question for this week, and thank you Sarah and Carolyn, was the relevance of common law to environmental protection. Would either of you like to provide a response to the question, does the common law have any role to play in the development of environmental policy and environmental law? You don't have to. Yes, Sarah?
I can. Like, my response is a bit short because I didn't have a lot of time to write it since I was traveling from Tokyo to Kyoto at the time. But basically the common law's role is, I suppose, as I pointed out earlier, common law and environmental law is in application and interpretation of statute, but also it's the adaptable law, I guess you say. If a case comes up in relation to legislation that doesn't quite fit in with how the legislation specifies it, then common law is there to, on the basis of intention, a statutory interpretation tells us, fill in the blanks of what the law should apply. And it also sets the precedent for how concepts specified in statutes, such as sufficient grounds in the SPA, for a legislation I've been looking at, is like defined what constitutes sufficient grounds. It's mentioned in the legislation, but it doesn't give you a exhaustive or even inexhaustive list of what might be sufficient. That is fleshed out in the common law.
Okay. All right. No, thank you very much, Sarah. I appreciate that. When you're referring to the SPA, you might be talking about the Sustainable Planning Act. So just refer to the Planning Act these days, if that's what you're referring to. But otherwise, that's very good. Thank you.
Well, I had looked at the SPA because it's the one mentioned in the case for the assignment.
Oh, yes.
So
that's
I
fair
had
enough.
gone.
Yeah, and that's the problem. You have to look at the SPA still now in relation to certain matters. Thank you.
Yeah.
Carolyn, anything you wish to add? You don't have to. But...
I, as mentioned in the answer, I kind of started reading chapter 3, and the answer was just there in the first section, where it just kind of nicely put them into 5 different sections of why common law obviously is important for environmental law. And I think some of the principles that we touched on today, namely compensation and remedies and so on and so forth, is really, if you're going to seek action, you'd be doing it through common law. And so it kind of, it talks about protecting fundamental social structures and but to me, it's more the remedies, I guess.
Okay.
But common law is law, so we can't, it takes 2 to tango.
Yes.
Can't,
All right. Thank you, Carolyn. Thank you, Sarah. Anyone else wish to contribute? You don't have to, but if you do. Yes, David?
I did go through the questions. I didn't post them up though, but I just looked at some examples of common law which still have fundamental effects even in environment law, such as the Mabo versus Queensland Act. That has fundamental effect on environment in terms of hunting and fishing rights in it, and it did talk about the protection of those designated areas in regards to those environmental rights in a way. So that's a piece of common law which is huge within Australian law, that is fundamental in regards to environment law.
Thank you. Excellent example. All right. Well, thank you all for your contributions this week. You've got a little bit of homework. You've got some encouragement from me to continue with the weekly problems and to upload some answers to those. All right. Anything else before we wrap up?
Yeah, I just wanted to have when I was looking at common law, I was looking at the environment sort of affecting common law as well. And I kind of have been reading over the last several months about how, climate change and environment changes is affecting, and there's a discussion going on in the legal world, not only in Australia, but around the world, with the concept of in contract law, which, as we know, is very influenced by common law more than legislation, and the idea of force majeure. And people are saying that maybe that concept of force majeure needs to be reviewed, because if you're going to have more of these environmental sort of catastrophes, then that's, as we know in force majeure, it excuses both parties from their obligations to the contract. So that could affect insurance law, transportation obligations, supply obligations. And so with the increase of these force majeure events, what does that really mean, in regards to climate change events?
That's an interesting perspective on the effect of climate change on the common law principles. Yes, no, I agree with that. Thank you, David. Appreciate that. Anything else? All right. Well, thank you all for your contributions tonight. Keep up the good work, and we'll see you next week for week 4.
Thank you, John.
Thank you. Okay, all the best. Bye then.